Hello and welcome to the Wake Podcast. I'm one of your hosts, Alejandra Moreno.
And I'm Taylor Kaufman.
So today we're going to be talking about some documents, estate planning documents, and they're not as sexy or talked about as wills, trusts, all the fun stuff. And it's advanced directives. So you want to talk a little bit about what advanced directives are, why we need them?
Right. So advanced directives are a set of documents that essentially come into effect while you're still alive, but you're incapacitated. So you're unable to make decisions for yourself. But these documents, unlike a will or a trust, they, come into effect while you're still alive. So it's kind of a different document in that sense. The three most common advanced directive documents in Florida would be a healthcare surrogate, a durable power of attorney, and a living will.
That's right. So when you say incapacitated, and we'll get into guardianships and all that stuff later, incapacitated is somebody that cannot make decisions for themselves, right? Okay, let's go through those documents that you mentioned. You said the power of attorney, right? So if you're incapacitated, and that can mean so many things, you can have a mental illness, Alzheimer's, dementia. You can be going through a medical procedure where you can't, make decisions at that moment. You can have an accident. You can be temporarily incapacitated. But the power of attorney, what it does is it gives somebody else the authority to make financial decisions on your behalf.
Right.
Financial decisions, selling real estate, paying your bills, access to your bank accounts, anything that has to do with banking, assets, money, all of that is covered under the power of attorney. Recently in October 2011, not recently. It feels recently to me. There was a change in the law where if you sign a power of attorney, your agent, okay, the person you're designated to make decisions on your behalf, they don't at that moment have the power. They have to sign an acceptance. But once they sign that acceptance, you don't have to be incapacitated. They have access to make financial decisions on your behalf as soon as they sign that acceptance.
Right.
So that's why it's so important when you're deciding on who's going to be your agent, your attorney, in fact, is what it's called. The person you authorize, it has to be somebody you trust. You can't have an inkling in your mind that they're going to go to your bank account and wipe out, your banks. And we've seen how banks treat power of attorneys in recent cases, and we'll talk about those. But once somebody has the authority to access your finances, you have to make sure that they're going to use them to take care of you. Of course, the law protects you, but if there is some wrongdoing, you're going to have to sue somebody to get it back, right? And if this is the person you trust, who's actually going to file a lawsuit? And if they're your power of attorney and you can't file a lawsuit,
exactly.
So it's like...
And we've seen that. And that's, a really big thing, like appointing someone or naming someone that you trust right now, and that you are going to trust in the future too, because once that document is signed and they have the authority, it's go time. Yeah.
A lot of people don't give the acceptance to their agent until they're ready, until they're older. But that's also kind of like a gray area, because what if you become incapacitated and nobody knows you have this power of attorney? You never told your agent that it exists. They haven't signed it. We keep copies of all, our documents. So if there is an emergency, we can help facilitate, the acceptance if we know the client, but we're not doctors.
Yeah.
So how do we also determine that this person is incapacitated?
Right.
So it's an important decision. You need to make sure you're naming the right person. So that's for the power of attorney. Next, we have the healthcare surrogate, which is for designating somebody if you can't make medical decisions on your behalf. So if you're going through a medical procedure, if you need to change insurance, if you need to consent to treatment, request medical records, anything that has to do with medical treatment, consent, access, authorization, because we have HIPAA. So you can't just, even if you're married to somebody, you can't just get access to somebody's medical records.
Right.
That's a big liability.
Yeah. Or even, when you turn 18, like I remember when I turned 18, my
right.
mom couldn't call and be like, what did the doctor say? Or fill my prescriptions or anything like that. So I remember signing something, when I was 18, I didn't really know at that time what I was signing, but, just to allow my parents to be able to call a doctor and get my medical records for me.
And we do have a lot of clients that have done their estate plan with us, and then their kids are going off to college, and they'll say, they don't need an estate plan. They don't have anything, but they really don't have anything. But they need a power of attorney, because what if they're up in, another city and something, God forbid, something happens, I need to know where they are. I need to be able to call a hospital, get access to, their information. So that's actually a great point that you make.
Yeah.
A lot of people have this misconception that advanced directives are for the elderly.
Yes.
People who are becoming incapacitated are elderly. But we've seen, unfortunately, we've seen early onset dementia. It's becoming a lot more prevalent. We see people that, have some kind of mental health issues, unfortunately, especially after the pandemic. It seems to have become more talked about, right? There's a lot more awareness. I actually, when I did my advanced directives, I was younger. I was actually in the best shape of my life. I was running marathons, and I was 6 months pregnant, and I got a terrible stomach ache, and I was rushed to the hospital, and I was in preterm labor. And I was obviously freaking out, but they started injecting me with all these weird things, all these to try to stop the labor. Obviously, you want the baby to stay in as long as possible. But with all of these chemicals, I did not know what was happening. Like, I didn't even know I was in labor. I was like, why am I here? And, my husband had to make decisions on my behalf. And he had my advanced directives on his phone. He just emailed it to the legal department, and within seconds, like, that's it.
Yeah.
I could finally relax. I could focus, and he could, take the reins on making it. Yeah. But I was young, and I never would have thought I needed them, but I had them before I needed them, which I think is a big deal.
Yeah. And you never know when you're going to be in a situation like that, right?
Of course.
You can't plan for those kinds of things. So that's a big...
You never know when the right time is, but I guess the right time is before you need them.
Right.
Which is, you can need them at any time, right?
Yeah, it's better to have it and not need it than need it and not have it.
Exactly. Okay, so the third document that you mentioned was the living will.
Yes.
So the living will is a document that states that if you have no chance of recuperation, you don't want to live artificially. So it's like a very legal DNR. The reason why you sign this document is because you're making the decision that you don't want to live artificially. If you don't have this document, your family members have to make that decision. So as much as, that decision is made with physicians, obviously, who have to determine that you have no chance, you're in a persistent vegetative state. You have no chance of recuperation. But wouldn't you, as a family member, feel a little bit of guilt, like you're killing, like you're pulling the plug,
right? Yeah, it's a
big
decision to make, and especially if they have this document, you already know what someone wants. It makes it a lot easier. This document was actually a really big issue in a famous Florida case, the Terry Schiavo case.
That's right.
Where the husband and the parents were kind of in a legal battle as to whether or not they should, keep Terry alive artificially or, pull the plug. So...
And this poor woman, she couldn't rest in peace because of this legal battle, and she didn't have this document, so nobody really knew her wishes, and it was like, there was a lot to that case, but that's a great example of, why this document is so important.
Yeah, I mean, imagine, being in that state or having a loved one, kind of in that state where they can't make decisions for themselves, and then going through a legal battle with a family member, that's hard too.
I think you're right, and I think the biggest point is it's avoidable.
It is.
It's all avoidable, and it's an inexpensive document. It's going to protect you. It's going to take care of you when you can't take care of yourself. And a lot of estate planning clients that come to us, and we give them some consultation, some information, and they really just want to talk about the will. They want to talk about the trust. They want to talk about the deeds, the real estate, and I'll do those documents later. Those aren't that important.
Right.
And I'm like, when your will, your trust, like, it's great. They're excellent documents, and I'm a big proponent, but you're gone. You're not even going to see how those work.
Yeah.
But what about you? Why aren't you taking care of yourself first?
No, it's important. And I've also, in my experience, I've had clients kind of say like, oh, I'm young. It's never going to happen to me. I can do these documents, 20 years down the road. Like, we're trying to start a family and buy a house. It's not that important, but it is important, just what we discussed. Like, you just never know what's going to happen, and people think they're invincible. And, I understand someone's young and healthy, but it's better to plan, and have these documents and not have them. And
I love that you mentioned that, going to college, because, we see our kids turning 18 and they're still our kids, they're still our babies, but legally they're adults. They're 18 years old. You don't have any right to any medical decisions, financial decisions, any information. And like you said, you might have the same doctor for so many years. So, your doctor will disclose to your parent. But legally, once you turn 18, they're not allowed to do that.
Yeah.
They're not allowed to do that. So, I think that even starting as young as 18, especially if you're going away for college, it's a very, very good tool to make sure that your parents are still able to help you.
Yeah.
If you're in trouble.
I mean, I don't have kids, but if I did, that would be something that I would definitely have done, you know, before they went away to college, like getting that out of the way and, you know, making sure we had that. So
awesome.
Definitely.
Awesome. I think this was nice. People don't like to talk about advance directives. People don't really know. They do know power of attorney, maybe healthcare proxy. There are different names for it, but the term advance directives and the fact that there's more than one is not very common knowledge. So so that was great. Thank you.
Thank you. All right. Well, until our next episode, thank you for joining us here at The Wake. My name is Taylor Kaufman.
I'm Alejandra Moreno.
From ASM Law Group, preserving what matters most for those who matters most.
Thank you. The Wake is for informational purposes only and does not constitute legal advice. The discussions in this podcast are meant to bring awareness to important issues, but they should not be considered a substitute for professional legal guidance. If you need legal advice tailored to your specific situation, please consult a qualified attorney.